welcome to this channel. Hope you all are doing great. Today we will learn a new Latin maxim, lex non cogit ad impossibilia. It is a Latin origin maxim. If we translate each word from Latin to English, it stands like this. Lex means the law or the body of law. Non cogit means does not force or compel. Ad means to. Impossibilia means impossible. In short, law does not compel impossible. The duty under law which is impossible is spare or let off. The another maxim similar to this very maxim is impotentia excusat legem. In other words, where the law imposes duty upon one and he is unable to perform without his fault and there is no other alternative, or it is impossible to perform such duty cast upon him, in such cases law excuses it. Maxim found its application at the time of war, an act of God's situation, impossible for the parties to perform. Neither the parties are at fault for the situation, or if done, otherwise will arise than the agreed terms. Very maxim finds its place in section 56 of the Indian Contract Act 1872. If the performance becomes impossible to perform, the contract becomes void. Under section 56, there are two situations when the performance becomes impossible. One is initial impossibilities, that is when an agreement is made to do an act which itself is impossible, and two is subsequent impossibilities, that is after the agreement the situation so arises that performance becomes impossible or unlawful. There is a well-known case in India, Punch Sons Private Limited versus Union of India, where the promisor entered into a contract with the Union of India to supply milk container with hot dip coating, for which the tin ingots were necessary for coating, and the tin ingots were cancelled item in the market. The promisor made several attempts to obtain it, and for which they approached the Director General of Supplies and Disposals. The court held that the contract becomes void owing to the impossibilities of performance and not liable to pay damages for the breach of contract. Section 56 of the Indian Contract Act is similar to the doctrine of frustration in England. In America, Justice Wentz in Hage versus GMS Development remarked that law does not compel the doing of impossibilities. Of the renowned cases where the court gave verdict on the basis of the very Latin maxim. 1. State of Madhya Pradesh versus Narmada Bachao Andolan, Supreme Court, 2011. 2. State of Rajasthan versus Hamser Singh, Supreme Court, 1985. 3. Shatyabrata Ghosh versus Mugni Ram Bangur and Company, Supreme Court, 1953. 4. Hari Prasad Chaubey versus Union of India, Supreme Court, 1973. The impossibility does not mean only the physical impossibility, but the actual or practical impossibilities in terms with the object of the performance so contended, and it need to be kept in mind. Such impossibility must be extraordinary in nature and circumstances.